apologies for the slightly late start. You guys keep a busy training schedule here, and certainly that's a great thing. But rolling in, got ourselves all rolled up. I'm told that someone has absconded with the clicker, so we may do this a little old school, where I've got to reference over there a bit. I think, as I mentioned the last time,
it could be Van,
I'm
Van
totally
Dave,
down.
exactly.
We're going to start with a raffle.
Oh, very
If anybody
good.
has a business card, or we're going to raffle off an umbrella.
We're going to start with that?
We're going to start.
Okay, we're going to start with that. Never done. Very good. I know who's boss. As Melody is working the crowd for those business cards, just a quick introduction. Hopefully all familiar faces at this point. My name is Ryan Stewart. I am with MBH Settlement Group. We have been one of your new title affiliates for the last month and a half or so. My office is about 10 feet that direction, so should you need anything, you know where to find us. As I've mentioned before, the goal is to create symbiotic relationships with you all. I've been doing this for 20 years. I've sat at the settlement table probably conservatively 15,000 times, so while we always are able to see that we haven't seen everything, and you probably experience that on a daily basis, I've seen a lot, and hopefully I can help you with your closings. We can be a resource for you and your clients. As advertised, we're kind of doing a slow waltz through the residential sales contract, month by month, as we parade through each of the provisions and take a much deeper dive. And certainly this is one of the more substantive ones. We spent about an hour on paragraph 1 in the preamble last month. Today we're going to go into paragraph 2. And really any discussion on paragraph 2 sort of has to then deviate into the financing contingency. So that's a big part of what we're going to discuss here today is financing. Any contracts class gets started, and I'll give that a tap. As I mentioned, just make sure you're using the right forms. I'm really just sort of waking you all up here, making sure everybody's ready to rock, but it doesn't do you any good to understand what the financing contingency looks like if you're using a dated version of the sales contract. And certain rights and obligations have changed as recently as this new version, which is dated 12/19. Financing contingencies all changed in 7/19. So just look down in the bottom left-hand corner of your contract and you'll see that revision under it. If you're not using the most current one, or if you get an offer that's dated, counter offer, use the most recent versions. They've been changed for a reason. Okay? Go ahead, click that again. Math counts, again, sort of warming you up with some softballs here. Right, you've got those provisions in paragraph 2, and for anybody that wants to reference what the actual contract looks like, at the back of your contract, I've got a credit denial letter we'll talk about, I've got the relevant pages of the financing contingency, and I've got page 1 of the contract. So that's in there if you want to follow along at home. And in there you'll see you've got those lines there for down payment, financing, first trust, second trust, seller subsidy, sales price, and so forth. Math does count. General rule of contract interpretation is that any ambiguity is interpreted in favor of the non-drafting party. Meaning that any time you're in front of a judge, court's going to look at it and say, who drafted this? Right? If you're the selling agent, you drafted something and you had a chance to make it clear, whether that's a home inspection addendum, a walkthrough addendum, right? Some sort of contract provision. You're the one that had a chance to make it clear. So we're going to look at it in light most favorable to the other party. And that's a big deal sometimes. $200,000 sales price, $800,000 loan for a $1.1 million purchase. Math counts, right? Certainly you've agreed to pay $1.1 million. There's no ambiguity as to what the sales price is. You've also said that I'm putting down $200 and I'm getting a loan for $800. If you've got a financing contingency, as we're going to see, that's your specified financing. And that's an impossibility for a $1.1 million property, so you might as well have just waived the financing contingency by goofing that up. All right? Just the same, those numbers don't always have to add to 100, right? By 100, I mean the sales price. You're offering $500,000 for a property and your client's getting a VA loan and they're financing the funding fee. Putting a down payment of 0, a loan amount for $515,000, and a sales price of $500. Right? Don't confuse yourself to think they all have to add to a bottom line. There aren't pluses and minuses over there on that page, paragraph 2. All right? Tracking. All right. Why is this all important? Go ahead, Mel. Go ahead again. Specified financing is an important term. Okay? Many of our clients need a financing contingency. If they're waiving the financing contingency, you can eat your lunch, you can sit out the next half hour. Don't worry about this. Right? But if they need a financing contingency, and even in this competitive market, many of our clients still don't know whether or not we can afford the home. We've gotten pre-approved, but this may be our first time, or we may be self-employed. Right? We're not W-2, right? Lender says, hey, this is going to be a little bit complex. We need our financing contingency. And if we need our financing contingency, it's important to understand the relevance of the term specified financing. In the financing contingencies, and paragraph 3C is automatic extension, paragraph 4 is automatic expiration. But for this purpose, it's exactly the same. We'll talk about the delta between those two in a bit. It's also the same for conventional FHA and VA. But the buyer can void by delivering to the seller a written rejection for what? The specified financing. Okay? So we now know by contract that if we want to get out under a financing contingency, we can do so if we're rejected for this defined term, specified financing. Okay? So what is that? Specified financing is defined in the contract. We know we've got this protection. What's the protection for? It means the terms set forth in paragraph 2A and 2B of the contract. And lo and behold, there's our paragraph 2. Very timely, since that's what we're talking about. Right? So specified financing includes our down payment. It includes our loan amount or loan amounts. It includes our loan type, conventional, VA, FHA. Go ahead. It also includes the following loan terms. Again, this is taken right from the financing contingency. There's the language. Terms set forth in the following loan terms. Are we assuming a loan or are we obtaining a loan? Is it fixed or adjustable? What's the term of years and what's the interest rate? Right? So every single indicia of the loan, the amount, the rate, the term, the type, that's all specified financing. And we know in the financing contingency that if we get rejected for the specified financing, we're okay. We get out under the terms of the contract. Now look at the importance of this. First off, selling agents. Your buyers have to understand this dynamic. You have to make sure they understand this dynamic before there's a ratified contract. That in defining what type of loan we're going to get in paragraph 2 of the contract and in the first paragraph of the financing contingency, we're establishing what our financing contingency is. We're not just haphazardly saying, well, I think maybe a 30-year fix. My lender talked to me about maybe going with an ARM, vacillating between FHA and VA. No, we got to know. Because if we deviate from whatever we've defined in the contract, it's not specified financing. And we can only get out if we're rejected for specified financing. So we have to have our clients understand that they're tethering their contingency to simply the terms and only the terms of the contract. Now for selling agents and listing agents, this is good. This is the framework we would like to create, just as long as all the parties kind of understand it. We want the buyer to first get introduced to the loan officer. Hey, good to meet you, right? Yeah, let me take a quick look. Okay, we see that you've got this much money to put down. Let me run some quick numbers for you, some credit. Okay, I've done the numbers. You can afford up to $500,000. And now we go forth, of course. We know what kind of loan we're going to get. We know if we stay under 500, we're good to go. And we write our offer. If it was the opposite, of course, life would be even greater chaos than it already is in the real estate world, right? I love these $1 million houses in Arlington. That's what I'm going to go for. I go right on a contract. 1-1. I like this house even more. And then come to find out I can only afford half of that. Right? It's got to work this way. It's just very important that we make sure that our buyers understand that it works this way. And for listing agents as well, it's an important consideration as well, because if the contract falls apart on financing and the buyer gets rejected and we get a written rejection letter, our core agency obligation under the Virginia Agency Code is to promote our client's best interests, right? So rather than kicking dirt and saying, well, back on the market, here we go again, let's make sure that the buyer really had the right to get out. And most rejection letters, I put it right on the back of your handout, are form documents. This is the Ellie Mae one, but there's Fannie, Freddie. Some lenders have their own, but they all look the same. It's not written on the back of a cocktail napkin and says, hey, sorry, we did our best, but we couldn't get you to the finish line. It's a template. And that template, in almost all cases, contains loan amount. It contains term. Most of them also contain the type of loan. And if we get a written rejection letter that says, hey, sorry, you've been rejected for your 15-year conventional loan, We said 15-year conventional, they told us they were getting a 30-year FHA. Well, the buyer doesn't get to get out under a different type of loan. They only get to get out under the specified financing loan. And so in protecting your seller's interests, you would expand upon that. Well, if you want to pursue them, we have every right. They breached the contract. They don't have the right to get out under alternative financing, as we're going to see. Do you want to go after them, or do you just want to sign a release and put the property back on the market? And they'll probably cut their losses and say, let's just move on. But you never know. And your job is to give them those options and make sure that you have shepherded them through the rights and obligations in the contract. Amazing.
I'm afraid. We're married. We're
Very good.
afraid.
So in reality, what happens, so let's say someone's close, but they get denied, is it usually someone, if they think they might be able to get it, will they give them more time to work it out, or what typically happens in your?
One of two scenarios. One, they just straight up get denied.
Yeah.
Lender says, we didn't see this skeleton in the closet before. There's just too much going on. We ran a quick credit check, you gave us a statement of income, but now that we unpackage this, you're not getting a loan. Or in the alternative, you've got a complicated situation, or I'm a crappy lender, right? In which case, hey, we get to the settlement, just gonna need a few more days. We'll get there. I've got every feeling we're gonna get there. Just waiting on this one document. And we're gonna talk about that a bit later and what that means for the parties, how selling agents can protect their buyers, listing agents their sellers, and so forth. But it's generally one of those two scenarios. All right. Interest rates.
It is the most nerve-wracking part for me, like at the end.
On the
Because
listing side or the selling side?
I think on the listing side.
Yeah, right. Because as we're gonna see, typically the financing contingency is still in place.
Yeah.
You haven't gotten the final approval, you're 48 hours before closing, the lender feels like they're giving you lip service, and everything, the whole house of cards could fall apart tomorrow and your seller's back on the market with no remedy.
It happened.
Right, it does happen, right? And all the more reason, to follow up with those lenders, to be taking contracts with lenders that hopefully have pre-approval letters, of which the buyer uses that lender, local lenders that you know about, and strong offers. I mean, the stuff does fall apart. There is an attrition rate, among closings, so. I've tried over the years just to sort of chalk it up as a cost of doing business, though, rather than being upset, just sort of accepting the fact that deals are gonna fall apart at the last minute. When they do, back to the drawing board. Right? Interest rates. We reference this language. Obtain, assume, fixed, adjustable. The interest rate for this loan is at an interest rate not to exceed blank % per year. Keep that again. All right? So that's our relevant language. All right. So we all know the process here. Again, you've passed the buyer along to their lender. They know they want to buy a house. They've got this nebulous idea of what they want to buy. They say, I got $100,000 in the bank. And right now I'm paying $2,400 a month in rent. I want to stay pretty close to that. And lender says, okay, let's look at this. $100,000, we can do an 80% loan, $400,000 loan. Interest rates are running right around 3.25% right now, right? I've estimated $500 a month in taxes, $100 in insurance. This is perfect. I can get you in for under $2,500. So long as you buy a home for under $500,000, we're all set. And you say, perfect. It's all fallen into place. And so they go forth and they move along with you and they write on one contract and there's 25 offers, and they write on another one and there's 15, and finally they write on one that's 450, they escalate up to 500, they waive everything but financing, and they get through, right? And they go back to their lender and say, good news, I got in at 495, right? I want to go ahead and lock in the rate, right? Their contract says I'm going to get a fixed rate loan for 30 years and an interest rate not to exceed 3.25. And the lender says, well, I've got bad news for you. Jobs report came out last week. When you met with me, interest rates were essentially at an all-time low, and they're now at 3.75. And so now you're trending more on this purchase around $2,675, $2,700, depending on where tax and insurance come in. Can the buyer walk? Can the buyer get out?
Yes.
Because rates are at 3.75.
Yes. What did they write in there?
They put 3.25.
Oh yeah.
And now the lender's saying they're up at 3.75. Can the buyer just walk?
Yes.
Okay. And don't feel bad when I tell you this, because I ask a ton of rhetorical questions, right? And 99% of the time, 90% of people get them right. And this question almost across the board, 100% of people get it wrong. Okay, click the button, right? One more time. Can the buyer void because they?
Oh, no, yeah, they can just.
Financing contingency. Anytime we set up a contingency, first it gives the remedy. You can void. But then it also defines how you can void, right? Home inspection. Can we walk in and say, I don't like the property, I'm gonna void? No, we have to give notice and a copy of the entire inspection report. FHA or VA appraisal. It doesn't seem like it's worth what I paid for it. No, we've gotta get the actual appraisal. Even HOA and condo, we gotta do it within a window of time following receipt of the documents. Same thing is true of financing. Just because we can't get the rate that we want doesn't mean we automatically get out. What we have to provide, click it, I think, a written rejection from the lender. And of course, the reality is just because I waltzed into the loan officer's office and I said, I want to stay around 2,500, has no bearing on whether I can be approved at 27, 28, 33, right? Because chances are quite good if I'm paying $2,500 a month in rent right now and I can afford it, that the lending guidelines, which allow me to get a loan for up to, I think it's 48% of my pre-tax income, lender might say, hey, you're not rejected at 27, you can afford it. Think of the tax break, right? Think of the savings. Actually, I ran the numbers, you could afford it all the way up to $3,500. You say, $3,500, that's insane, right? But nonetheless, if you can't get the written rejection from the lender, you can't get out. And again, take a look again at what the rejections look like. There's nothing on there that says buyer can get out because they don't like the interest rate or the mortgage payment. There has to be a reason that they've been rejected. No credit file, delinquent credit obligations, bankruptcy. The very closest that we get is an E, other. And again, this template's pretty uniform. We do not grant credit to any applicant on the terms and conditions you have requested. Something similar to that. Now, can the lender give 3 1/4? Yeah. You want to pay me $10,000 up front in points? We can get you down to 2 1/4. Give me as much money as you can. I'll keep moving that rate down. I don't offer it with no points, but of course points aren't considered a part of the specified financing. I didn't say I'd get 3 1/4 with 0 points. And so this too is an important consideration for your buyers. Lender may do them a solid, paper up the rejection letter and say, go ahead, you can walk. All the more reason to have a lender that you've worked with 100 times because maybe there's a little accountability, maybe they'll blur the lines a little bit, right? But them rejecting them has an impact on them as well. They're not in the business to be rejecting borrowers. Their management's gonna say, why did you reject this borrower when they've got 800 credit and make $100,000 a year, right? You get the letter, you can get out. Otherwise, you're stuck in the deal. Okay. Stress that to your buyers, right? The process, of course, meet with the lender, find out what you can buy. If a couple days or a couple weeks have gone by since we met with the lender, before we write that contract, let's call the lender to make sure rates are still 3 1/4. We found out today they're 3 1/4, we put the offer in, we negotiate for a day, and then the very next day, we go and we lock that interest rate in. Because if rates rise up to 3 3/4, because we think it might go down to 3, we're out of luck unless we can get rejected. So we've talked about the financing contingency being loan sensitive, it's also time sensitive. All right, loan sensitive specified financing. Time sensitive, I've got to make written application for my financing and any lender required property insurance no later than 7 days following ratification. All right? So selling agents, again, yet another point we're stressing to our clients. If you want the benefit of that financing contingency, it's for your specified financing, and we got to get that application in within 7 days of ratification. Because if it's for the specified financing and we make it on day 8, if the other side can prove that, we have no financing contingency to hang our hat on. We didn't make timely application. For a listing agent as well, you're presented with this rejection letter. It looks like the specified financing. If you really want to take the next step, contact the lender. I need to know what date application was made. If they say I can't tell you that, we're going to talk about language also in paragraph 2 where it does authorize the lender to disclose that information, or if you really wanted to go after them, you could certainly depose them. I understand we're probably not going that direction, but again, it's time sensitive. So in representing your client's interest, that's yet another checkbox that we want to address. All right? Property insurance as well. they have to make application for their insurance within 7 days. If they file the application, do nothing with insurance, a week later, maybe they call their lender, say, hey, I'm gonna have to get in touch with you the next week to get insurance. Lender comes back, says, yeah, this property's actually distressed. We've got issues with it. It's gonna be $200 a month. On top of that, we just looked, it's in a floodplain. That's another $200 a month. And if now all of a sudden the buyer can't afford that and the lender rejects them, if you can prove that application wasn't timely made, seller's got a cause of action. So we've got to get our buyers moving on this. And all of this is beneficial for us in the industry, for us that want to get to the finish line, for this transaction to be consummated. We all want these pressures in place for a buyer to start moving. We don't want to be out lender shopping 3 weeks after closing, rate shopping a month later, thinking about some different insurance providers, right? Let's get this all done. That's how we get to settlement on time. All right. Can the buyer amend the terms of their financing? This is that, right? You all are scared of the rhetorical questions. This is the one. Can the buyer amend?
They can do whatever they want.
Yeah, there we go. 100% of you are correct. Right, go ahead. Alternative financing. This is the alternative financing provisions in the contract in paragraph 2 of the financing contingency. We got all sorts of stuff expanding upon. Buyer has every right to change the terms of their financing. We first see that alternative financing, and this buttresses our discussion we've already had on specified financing, it means any change. Any change to down payment, loan amount, loan type, right? Whatever change we're making, we're now in alternative financing. Buyer may substitute alternative financing for the specified financing. However, we've got 2 conditions. We've got to obtain the seller's consent. We've got to execute a new financing addendum if we want to preserve the benefit of the financing contingency. And if we do so without it, we're waiving the contingency. All right? So let's unwrap this a little. Buyer shall obtain seller's written consent. What's that about? There's a bit of language right here in the contract that I loathe, and I've got great respect for the Forms Committee. They've done a Herculean job of getting this to being a good contract, but there's still a couple of faults in it. This is one. Buyer shall obtain seller's written consent. Like I envision this, like, will you allow me to change my loan from fixed to adjustable? You know, check yes or check no. You know, like 5th grade. Erica Batten, will you go out with me? Check yes, check no.
That's
Right?
a real lady from Tibbs, by the way.
Right? It's such pedestrian language, it just makes no sense to me. What we're talking about here in terms of obtaining seller's written consent, first off, we're talking about an addendum, right? If we're getting consent, that means a bilateral agreement. So there's got to be an addendum in place. And further, it's not I consent to you getting a fixed rate loan, but rather the terms, we're changing the definition. Specified financing is a defined term. We're just simply changing the definition. And so the buyer's specified financing is hereby amended from fixed rate to adjustable rate. If that's all we're changing, there we go. We've changed our definition of specified financing such that now the specified financing is not necessarily what's in paragraph 1 or paragraph 2, but it's paragraph 2 supplemented by this change. That's obtaining the seller's consent. And then even more nebulous language, and we shall execute a new financing addendum if applicable. I think we need a decoder ring like that. Like how do we know if it's applicable or not? Can you help me out here?
If it happens.
What they're referring to here is anytime we are changing from where our financing is a non-FHA loan, and we're changing to an FHA loan. And also when we're changing from a non-VA loan to a VA loan. And the reason this has been put in there is not that it really has anything to do with the specified financing or the parties' rights, but it's an olive branch to the lenders that were on the Forms Committee. Because the lenders on the Forms Committee, when I'm going from a non-FHA loan into an FHA loan, I've got to have the appraisal provisions language as part of the contract. It's a statutory protection to the buyer that says if the property doesn't appraise, the buyer can automatically void. If I'm going from a non-VA loan into a VA loan, I've got to have the amendatory language, which says the exact same thing. If the property doesn't appraise, the borrower can void. And it's regulated, required language that in their underwriting guidelines, when they are getting an FHA or a VA loan to the finish line, they got to have that language in there. And so what the Forms Committee has come up with here is to say, okay, get the seller's consent, and then if it's applicable, which essentially means if the lender tells you you need it, then you all will also have to go get a new financing addendum drafted, either the FHA or the VA one, whatever's relevant. Okay. Now, the question always comes up, do we need to do this? From a buyer's perspective, as the selling agent, the counsel is, well, we need to do this if we want to keep the financing contingency in place. If we feel really good, if the lender's already said, hey, I've already approved you for this, we're just changing from fixed to adjustable because you just told me you're only going to be in there for 7 years. There's no reason to go with a 30-year fixed when we can get you a half point off. But you're approved all day long, 6 ways to Sunday. Well, we don't necessarily have to go through the mechanics of this so long as we understand, hey, we're trusting you on this. We're not going to try to preserve our financing contingency. We're just going to march forward. Otherwise, we want to entertain getting this addendum executed. Flip side, from the listing agent's perspective, we're presented with this addendum. Do we sign it? I mean, first off, we're well within our rights to say, hey, go forth. We're not going to sign anything. The contract gives you the right to substitute alternative for specified. You don't need my permission. You say, well, yeah, I need your permission if I can keep my financing contingency. I get that, but I'm much happier with you getting rid of your financing contingency. My seller's in a better position if you don't have your financing contingency. But in this case, of course, there's a risk-reward. There's a cost balance here, because if the lender's coming back to you and says, sign what you want to sign. I can't put a gun to your head, but if that addendum isn't signed, we're not closing. Further, if we're 3 days after closing and the buyer's still got home inspection, HOA and condo, that they could void on anyway, well, why hang them up over this? Let them go forth. Let them get the loan, so long as it doesn't significantly prejudice your rights, which I understand. If we're going into VA, we're now opening ourselves up to VA repairs, right? So heaven forbid if a spindle on our staircase is loose, right? You'll have to fix it, right? We're also opening the buyer up to having that unilateral right to cancel. But good offer is a good offer. If we're going to march forward and this is the bird in hand and they could void on us otherwise, maybe you just go ahead and sign it. But it's always going to be that cost-benefit analysis. Where are we in the process? What's the hazard of signing? The buyer switch lenders. So this has been a gradual evolution and in the wrong direction for me, unfortunately. Prior to 2012, it said the buyer will be in default if they choose an alternative lender, one other than who provided the lender letter. And we made the argument based on the language of the contract that that was the pre-approval letter, that a buyer was tethered to who gave them the pre-approval letter. I always liked that because that was a big reason you took their offer, because it was the lender in your office who you can go scream at if the buyer can't get their loan, and you felt really confident in accepting their offer on the listing side, or somebody you've heard of, and then all of a sudden they get rejected by their cousin who's an internet lender out of California. Right? And then they moved away from that, and up until 6 months ago, there was language in the contract that said the buyer could switch to an alternative lender, but if they failed to get to closing, they'd be in default. And we could distill down the provisions of the contract to state that a specified lender was who I made that application with within 7 days. An alternative lender would be anybody I made application to after 7 days. And so I like that too, because it says, hey, go forth, get your loan within the first 7 days. If you switch and you can't get to the finish line, you're going to be in default. And I like that as a seller because I don't want you switching last minute, because that jeopardizes my chances of getting to closing on time. Well, for reasons to me that are still unknown, this language now, buyer's substitution of lender to which application has been made under 2D shall not constitute a change in specified financing, or constitute buyer default, provided no additional expense or settlement is not delayed. So they are now saying exactly the opposite. Feel free to switch lenders, right? If you do so long as it's for you're rejected for your specified financing, so long as you still made an application with somebody within the 7 days, so we can check that box, you can get rejected by somebody you made application for after 7 days. The logic that I was told was that if a person made application within the first 7 days, they were doing their job. If they made application with someone else later, if they were going to take that loan, they would only do so because it was a better deal for them. And we don't want to put a framework in place that disincentivizes the buyer from trying to get a better deal. If they can get lower costs, we don't want to put roadblocks in front of them. I would agree with that, but for the absurdity of ignoring the fact that we want them to make application in the first 7 days because we want to get the ball rolling. Getting approved for financing takes time. And the longer we wait following the ratification date to make application, the less our chances of getting to closing on time are. And so if we allow a buyer to haphazardly make application with another lender a week before closing, when we've been sitting around for 2 months working with lender number one, we're dramatically compromising our chances of getting to closing. And if lender number two says, yeah, 30-year fixed, you know, you're getting the same loan you put in the contract, and I could probably get you to the finish line, but there's just not enough time. So I'm going to go ahead and sign this rejection letter under whatever pretext I can put it under. Well, the buyer would be able to walk. And unfortunately, that's what the contract says, right? So a buyer were trying to desperately get out of a contract, and he said, I'm working with lender A, and they say, yeah, I can get approved. Any advice on how to get out of this? Well, a number of different ways, but one of the ones, hey, make an application to another lender. Maybe they'll reject you. As long as it's for the same loan, all right? Can't hurt you. See what happens. But the reality of it is, unfortunately, they can switch. Did you get a little carried away on me
Got
there?
me pointed. Very hard.
Rick, can I get you back up here? Good help is really difficult to find.
Give it one more chance.
One more chance, everybody. All right. All right. Contract is contingent. We're changing gears. Contract is contingent till 9 p.m. This is our financing deadline. Upon buyer providing written conditional commitment for the specified financing. Sellers looking to remove the selling agents looking to remove the financing contingency. What document do we provide?
Commitment letter.
Huh? There you go. Conditional commitment, right? That's what it says.
Yeah.
It's a trick question. Sorry. Baited the hook. Right? You're never, ever, as a selling agent, going to provide something removing the financing contingency. Okay? I'll repeat that because it's an important point. As a selling agent, you are never going to provide any affirmative document in your whole career removing the financing contingency. Financing contingency with automatic extension. Language in there that unless it's removed, it continues to protect the buyer up to and including the settlement date. So we're talking to our lender, we're 3 weeks in, and they say, you are the best candidate I've ever had, we've got you completely approved. You'd feel pretty comfortable providing that, and here's not even a conditional commitment, here's the full commitment, right? You'd feel pretty comfortable providing that to the seller and removing the contingency. The problem is if there's layoffs tomorrow or next week, when the lender goes to do their final verification of income, assets, and employment 3 days before closing, they're going to see I don't have a job anymore. Guess who's not going to get a loan? And if I've done nothing, that financing contingency is still going to get me out under the contract. I send my rejection letter, I get my EMD back. If I remove the contingency, I'm out of luck. Right? If I die on the way to closing, guess who's not getting a loan? Right? Yet nonetheless, the entire agreement paragraph 38, says the contract is binding upon heirs and successors in interest. Well, now my heirs either have to buy the property or lose the EMD, or my estate is exposed to a potential lawsuit. If I've left my financing contingency in place, I get out. Written rejection letter is provided, I'm dead, get my EMD back. Now there is language with the automatic extension that once we get past the financing deadline, the seller has some rights. Not much, but the seller has some rights. The seller may deliver, oops, I'm off camera. The seller may deliver notice to the buyer. Buyer has 3 days to void the contract. This is after the financing deadline. And if the buyer does not void, the contingency is removed. So again, what are the rights when we get this? We can do nothing, and the contingency is removed. Or we can send over notice voiding the contract, and the contract is void. But you'll see again, we never get back to providing any sort of document to remove the contingency. So it could say a conditional commitment, it could say Form 100, right? It could say your subscription to a Jelly of the Month Club. Like, it doesn't matter. It can be anything, because we're never going to provide it. We're not going to proactively remove the contingency, and even if the seller forces our hand, we're either going to send notice voiding or we'll just do nothing for the 3 days and the contingency goes away. So it's irrelevant what we're providing. Now, listing agents, go ahead and ask for that conditional commitment. That's your job. Be the squeaky wheel. Because 9 out of 10 agents will say, I'm working on it, I get it, hey, we're in this together. Right? We're not in this together. I represent the seller, you represent the buyer. Those are completely contrasting points.
It's the reputation, it's the win-win.
Bull! I get it, we all listen, but your job is not to build a strong reputation. Try arguing that to NVAR. Your job is to promote your buyer's best interests. Why did you remove the contingency? Well, the other agent's in my office. I got a rep to protect. I get it, and I wholeheartedly respect that. And in most cases, like, yeah, we want to move along together. But in the case of removing a financing contingency, it never serves your buyer any positive benefit to remove it. So it's real hard to argue why you counseled them to remove it. There is no justification for it. And that's the challenge with financing contingency. If the buyer comes forth and says, I didn't know if I lost my job, I wasn't going to get it. He told me I was approved. Why did we remove this contingency? Like, you told me to, right? Now, all of a sudden, we've got problems, right? So leave that contingency in place. Go ahead. Okay. Following financing contingency, the financing deadline, is the seller ever going to send that notice to void? 2 situations, and only 2 situations. 1, I got cold feet. I don't want to sell the property anymore, right? Or 2, I don't like this buyer. I want them to void because I got a better offer. All the other houses are going for more than they were a month ago. So the call I get often from sellers, because they have no way out of a contract, is I want out. How can I get out? Well, if you've got the financing contingency with automatic extension and you're past the financing deadline, send that notice. And with any luck, the buyer feels backed into a corner. They don't feel comfortable allowing the contingency to be removed, and they say, well, let me cut my losses before I create liability. But that's about it. You're never going to send it proactively thinking, well, let me force them to remove the contingency. Unfortunately, that does you no benefit. You may bluff, and they may let the 3 days go by, but you also may bluff and they may void a perfectly good contract. So you're only sending that when you got cold feet or a better offer.
Or the buyer is a little iffy.
Right, we don't like them.
And you're not sure.
We don't like
if
them.
they're gonna close or not.
Ryan, I have a question on that. From what I understand, I'm on the forms committee. From what I understand is when you do.
You came in after I was being attacking of the forms committee, right?
No, I was listening to all the comments. I've been listening to
We've
all
had
the
this
comments.
conversation already.
So when you do give them that notice, what I understand is that the buyer can void, not just because of financing, they can void for any reason entirely.
Yeah, so they're
So they change their mind about the roof or anything like that, and that property inspection has already passed.
here's notice voiding.
The seller's giving them an opportunity, they can still void based on that
Yeah.
contingency that passed a while ago.
You opened up a window for me.
Yeah.
You gave me 3 days to void for any
Any
reason. This may have been, stroke of good luck because I was trying to get out of it anyway and I couldn't get out of it any other way. Right? You're opening up that opportunity for it. All right. Go ahead. Buyer hasn't been rejected but needs more time. This was our scenario, which oftentimes happens where, of course, the lender is just not ready on the settlement date. Should the parties execute an addendum extending the settlement date?
Yes.
So the epidemic behavior here is the listing agent driving this practice. This belief that if we get to the settlement date, and if the buyer doesn't close, that I have to do something to preserve the contract. That if somehow if we get to the day after closing and the buyer hasn't closed, that I've lost my rights and remedies, that the buyer can void, or that there's no contract. Right? The reality, of course, is that when we get to the settlement date, Time is of the essence. The buyer has a burden or an obligation to close. If they don't close and we get to the next day after the settlement date, you still have a contract, but the buyer is in default. And the buyer being in default, the seller has the rights to pursue them. I could go after you for your earnest money. I could sit and wait it out. I could ultimately get the property back on the market, see what my damages are, sue you after that, right? I have all possible remedies at my disposal. And those remedies don't just exist for a day or a week or a month. They exist for 4 years from the contract date. That's the Virginia statute of limitation on written contracts, right? So there is no sense of urgency for me as a listing agent to force this extension, right? Go ahead.
So what, if the seller wants it back though, what kind of notification, if any, do they have to provide?
If you get to the day after the settlement and the seller doesn't want to sell it,
Yeah,
question is, does the seller want to pursue him for EMD or damages, or does the seller just want to get it back on the market?
just get it back on the market.
Okay, so you're in the catbird seat.
Yeah,
You had to close yesterday.
yeah,
You didn't close,
Yep.
so now you're in default.
yeah.
So I'm going to give you this release, and I'm even going to give you your earnest money back because I just want to sell it to somebody else. If you don't want to sign the release, I'm still going to sell it to somebody else, but I'm going to sue you for my damages or the earnest money. A much better position for the buyer to be in is say, perfectly fine, I really wanted the house, I can close today, you sure? Sign the release, right? The analogy I always give here is I'm getting married on a Saturday, and I hire the caterer to bring $10,000 worth of food, and the caterer shows up on Sunday, says, look at this food, huh? $10,000, please. I say I got married yesterday. I'm not paying you $10,000. Time is of the essence. You don't get to close anytime you want, even if it's a day later. You get to close on the settlement date. Because you didn't, you're in default. Now, if the seller wants the money, which is often the case, they want to exact the pound of flesh, again, contact the selling agent. My seller's putting it back on the market. They're not selling it, and they're going after for the EMD. And if you don't want to release the EMD, we'll put it back on the market. We'll figure out what our actual damages are. And if it takes us 6 months to sell and the market nosedives, right? This is Sandbag v. Reyes, which is a well-known case in the Alexandria courts where a $10,000 EMD became a $78,000 judgment against the buyer, right? But if the buyer doesn't sign the release, keep in mind the contract doesn't just go away. If your seller still wants to pursue them, wants to get it back on the market, call an attorney, because the attorney will properly paper that path so that they're not obligating themselves to sell the same house to two different buyers. Okay, if the seller has not delivered the commitment by the deadline, the contingency will continue up to and including the settlement date. There's that language again. So we have a financing contingency in place up to the settlement date. And our hypothetical was, of course, we're now the day after closing and the lender just needs a few more days. So do we have a financing contingency at this point as a buyer? No, because it only protected us to the settlement date. The settlement date was yesterday. So a listing agent having an addendum signed that says settlement is extended from today until February 12th, we've changed the definition of settlement date to February 12th, we've extended the buyer's financing contingency. That's not what a listing agent wants to be doing. By contrast, of course, the selling agent, that's exactly what they want to be doing. Settlement's going to be delayed. The very first thing you need to do is to get an addendum. My broker needs it. My lender needs it, right? Hey, can we just do this? We're looking really good for the 12th. Whatever, but you need that addendum signed because you're not only your buyer's not in default, but you're extending the benefit of the financing contingency. And to couple both of these together, the buyer sends over the addendum. Settlement date's been extended to February 12th. The seller makes a counter. It's been extended to February 12th, and the financing contingency is hereby removed. And the buyer gets that back and says, we're not going to sign that. It's like, here is your predicament. If you sign it, you're not in default, and you have no financing contingency. If you don't sign it, you are in default, and you have no financing contingency. Which one's a better position to be in? Either way, you've got no financing contingency. I'm just giving you a chance to not be in default for a week. Right? You run the risk otherwise that my seller gets moody next week and says, hey, I'm not selling it to him. Or somebody knocks on their door and says, I'll give you 10 grand more. And now I'm suing the buyer, right? Rather than closing with them next week. Right? So a selling agent would be well served to sign that once you're after the settlement date because you really have no strength to hang your hat on. Okay, go ahead. Automatic expiration, real straightforward, right? Kind of works like home inspection, right? You got a window of time. Here's your financing deadline. Whatever happens after the financing deadline is irrelevant. You have no further financing contingency. Seller has no rights prior to the financing deadline. Doesn't need to do anything after the financing deadline. It just goes away, right? So preparing your contract, buyer wants automatic extension. Paragraph 3, seller wants automatic expiration. Paragraph 4. All a matter of leverage, right? In this market, if you're trying to distinguish your contract, pick a good lender, try to build a long financing deadline, and go with number 4, right? If you're the buyer, right? If you get away with 3, have at it. But you get the idea. Go ahead. Buyer overstates income on the application and is rejected for the financing. Buyer in default? Feels like they should be. I agree that they should be, but unfortunately they're not. So there has been this trend in the contract away from ambiguity, but also unfortunately away from equity. Again, prior to 2012, there was this language that says a buyer will be in default even if the financing contingency has not been removed if the buyer is rejected for any of the following reasons. Fails to lock in an interest rate, and interest rates rise to a level they can't afford. Misrepresentations or omissions with the lender. Any overt act that impacts their ability to acquire financing. Property insurance was on there. Right? This whole laundry list, y'all may remember that, it was like 7 different items. And unfortunately, every time a buyer got rejected, a seller wouldn't sign a release. And they'd say, well, I know you got rejected, but the reason you got rejected must have been because of something you did. Because you got a pre-approval letter, you were good 2 weeks ago, now you're not good. So something must have gotten sideways in between and it's your fault, so I'm not going to sign the release, I still want your EMD. And so the forms committee said, well, we got to get rid of that. That's poor language because really every buyer is being held to the fire for things that they shouldn't be. So they changed the language, says buyer must make prompt application for their financing and must diligently pursue approval for their financing. And so a buyer, quits their job 2 weeks before closing, and the seller says, well, you still got a financing contingency, but I'm not letting you out. You weren't diligently pursuing your financing. You quit your job. The buyer says, on the contrary, I was so deliberately pursuing it that I quit my job to focus 100% of my time on obtaining my loan. Right? Still nebulous, still ambiguous. And so the decision was made to make this very black and white. Buyer may void by providing a written rejection for the specified financing. It doesn't matter why I was rejected. Okay? If I said I made $1 million, turns out I make 1/10 of that, tough. Do I have a written rejection for my financing? Yes. Right? I wouldn't want to be the counsel for the seller trying to litigate this. There's a doctrine in contracts called the parole evidence rule. It says if I can determine rights and obligations by looking at the 4 corners of the contract, I'm not going to look at anything else. And the 4 corners of the contract say, you got a written rejection? Yes. Is it for the specified financing? Yes. Did you make application within the 7 days from ratification? Yes. You're out. We're not going to look at why. We're not going to look at what you did. Right? Now, there is an underlying thread of good faith that runs through every contract. And so if you were to end up in a court, let's say the buyer the day before closing calls the lender and says, what can I do to get out? So it's pretty much nothing. I mean, I guess you could go buy, a Ferrari. Perfect. I'm buying a Ferrari. Here's all the paperwork. Reject me. If that could be proven, I think a seller would have a good argument. I just wouldn't want to be the one trying to make that argument. And I would tell a seller, it stinks, but it's not worth pursuing. No. All right. We're done financing contingency. Home stretch here. Seller subsidy. This is the language from this is the definition from paragraph 31J. The seller subsidy, of course, is referenced in paragraph 2. This is what we remind our sellers of, this highlighted language. Including but not limited to. There is no limitation to what a lender can use for a seller subsidy, for a closing cost credit. And I've experienced far too many times a seller who comes up with their own definition of a closing credit. I'm going to offer you $10,000, but in the back of their head, they're like, how can it possibly be $10,000? We're talking maybe a settlement fee, maybe some title insurance, an appraisal. And then they go in and they find out, of course, that the lender has used all $10,000 and they're mad at you because they don't agree with the definition of seller subsidy. Just tell your sellers that money's gone. right? It's coming off the top, it's gonna go into your net. Go ahead. More importantly for your buyers, of course, it's the buyer's responsibility to make sure they can use the entire credit. And if they can't, it gets reduced to the amount allowable by the lender.
Now, if the seller's agreeing to pay some points, is that part of the seller subsidy, or is it?
It's not so much the seller's agreement to pay points,
Yeah.
it's whether the lender will allow it to be used towards points, and lenders will.
Okay.
And that's why any lender worth their salt, I mean, unless you've got like a 10% closing cost credit, the lender's gonna find a way to use 3% of the sales price, right? And so your sellers, they're gonna forfeit that money, but you don't need to define that it can be used also for points. It's including but not limited to anything the lender wants to use it for. But for the buyer's purposes, if the lender won't allow them, they lose that money. In the interest of good faith, if the seller wants to provide them some sort of extra credit, right? You weren't getting a home warranty. Can I buy that for you? Have at it, right? Or here, a little housewarming gift. There's a $500 gift card to Home Depot. Have at it. Lender doesn't want to know about it, but they don't have to. And there's no ability for the buyer and their agent to say, well, we could only get $9,500, so we want to figure out a way to get that additional $500. You've lost it. The seller wants to give it, have at it, but it's not the seller's fault that the buyer didn't do their homework.
I was gonna say, you saying it's only for lender charges?
No, it's for anything.
It's for anything, okay.
Go back to Oh, don't worry. Yeah, it says towards seller's charges, including but not limited to. And it goes through a whole myriad of things. No, it can be for anything. And lenders are creative. VA loans, they'll let them pay off car loans, student loans. I mean, you can have tens of thousands of dollars of debt on there that the VA will allow if the seller's not, if the credit's too big and the buyer's still got some room on it. FHA, conventional, they'll typically allow you to pay up to 1 year of association dues, up to 2 years of home warranties. I've even seen lenders allow principal reductions because they've got their own definition. But again, work with the lender. This shouldn't be your explanation to your buyers. Put your buyers in the hands of the lender and let them explain it and make sure they can use it. Just a few laundry items here. Listing agents, reach out to the lender. Establish that communication. You stand in a much better position of being able to give good counsel to your sellers in doing so. If you call up the lender in this day of privacy concerns, the response you may get is, well, I can't really communicate with you without the buyer's permission. Here's the permission. It's in paragraph 2 of the contract. This isn't the contingency, it's first page of the contract. The buyer grants permission. Cooperating brokerage and lender to disclose to listing brokerage and seller general information about loan approval. So send that over to them. If they say, well, that's still not good enough, right? So that's fine. Reach out to the selling agent and say, hey, I need to have a communication with the lender. The seller has already been granted permission. I've been granted permission, but the lender won't allow it. Can you facilitate that? It's about the best you can. And then every once in a while, we've got a dyspeptic seller. I'm not letting the appraiser in. They can do it from the outside, right? I'm not signing those VA forms. If they need anything else, they can sue me. Here's where they've already agreed by contract to do it. A seller has agreed to comply with reasonable lender requirements, and all of these are perfectly reasonable within the scope of a resale transaction. There we go. Guys, that is everything. We are right at 1 hour, which is exactly where I hope to be. Thank you very much. I appreciate it. If you have further questions, certainly don't hesitate to pop by. Sometime in March, we're going to consolidate paragraphs 3, 4, and 5, deposit, settlement, and settlement date, and we'll go for about the same term. And we'll continue to do this as long as you all continue to show up and enjoy it. I appreciate it. All right?
All right, thanks.
Oh, what about the raffle?
Oh yes, raffle. Anybody going anywhere? Let's see who we got here. Melody. There you go. Very time appropriate gift for today. A rainy day.
Perfect.